Good day, everyone. You're listening to The Real Truth. I'm Tommy Spina. Today's guest is yet again Barry Ragsdale. Barry has filed the lawsuit in Montgomery County on behalf of two veterans out of Mobile County, I think, seeking to answer a question I thought as a 75-year resident of the state of Alabama, can a Florida man be Alabama's governor? Welcome to the show, Barry.
Thank you, Tommy. I appreciate it.
Did I sum it up?
I think you did. I think
should we hang up now?
We're done. Thank you for your attention. Yes, yeah.
Isn't that the bottom line?
No, very much so. It is, and it's even more than that. It's a question of, can somebody who doesn't live in Alabama run for governor of Alabama, and nobody gets to question whether or not he lives here or not, is really kind of ultimately what it boils down to.
Oh my goodness. Needless to say, you have done something that most lawyers in this state, well, I don't think most lawyers in this state even talk about it. You've actually dragged a powerful politician into a court over a constitutional lie, and won before on one occasion, and now you're doing it again. I introduced you last time you were on the show as a Birmingham attorney, and you're standing in Montgomery County on behalf of two honorably discharged Alabama veterans, Brooke Dorgan and Justin LeBlanc. And you filed a lawsuit to keep Tommy Tuberville off of the November ballot. The question, as I said before, is not that complicated. So there was a hearing on Monday on the defendants. That would be Tommy Tuberville, who is represented by Joe Espy, another lawyer friend of mine, on their motion to dismiss. Can you enlighten us on the position that they're taking and why they feel a motion to dismiss is due to be granted by this judge at this time?
Sure, I will try to. They have challenged the jurisdiction of the court in Montgomery to hear this challenge that we have filed, based on their claim that the only people that get to decide the qualifications of people running for governor are the two political parties. And so their position is that the Republican Party has already decided that Senator Tuberville is 100% qualified, and that the courts don't have any jurisdiction to second guess, I guess, or examine their conclusion. That's essentially their position. And, it is true, I will say, there's a kernel of truth in what they have argued, is that courts generally want to stay out of election disputes when it is a question for a political party to decide how they conduct the primary or who their nominee is. That's generally true. Our position is, I think, equally simple, is that once you certify as a political party, once you certify to the state that this is our nominee and we're going to live with it, that at that point it's no longer a party matter. And we believe the courts have a place in interpreting certainly the Constitution. So that's what the argument kind of boiled down to yesterday.
And specifically, we're talking about Article 5, Section 117 of the Alabama Constitution, which essentially says you have to be a resident for 7 years preceding the election date, which is November, which would mean that he would have had to have been a resident citizen of the state of Alabama from November, whatever election day is, I don't know, early in November, usually, right. 2019.
Correct.
And it's not just a mere domicile. There has to be an actual physical presence and an intent to have Alabama as your residency. Am I wrong on that, or am I letting my criminal defense world creep into my brain?
You are absolutely correct. It is more than owning property in the state. You know, a lot of people own houses or property in more than one state, and it is essentially, it boils down to, where do you lay your head at night when you go to bed, and where do you intend to stay as your permanent residence. And that's the definition that's used, you know, not only for candidates, it's also used for voters or any number of other reasons for purposes of residency and domicile. And that's the legal test. So, you know, what it really boils down to is from, say, November 5th, we'll pick that as the date, 2019, you know, for 7 consecutive years, did Tommy Tuberville live in Alabama? We think that evidence is overwhelming that he did not. And that particularly, and let me say, some people have pointed to, and Senator Tuberville raised as well, he's been in the United States Senate. And, you know, senators spend a lot of time in Washington, D.C., as do other people that work for the federal government. So, you know, the fact that he might not have been in his house that he claims he lives in Auburn for those, you know, years that he's been in the Senate. But we're really talking about a time period that we think is most important, is from November 2019, as you pointed out, until late January 2021, which is really when he took office for purposes of the Senate. And so there's a year and a couple months in there that we think the evidence is very clear that he didn't move to Alabama, didn't intend to move to Alabama, never lived here. He told people he lived in Florida. And so we want an opportunity to present that evidence, which we think, as I said, would definitely support the conclusion that he doesn't meet the constitutional durational residency requirement. We want to present that to a court, maybe even to a jury. That's the last thing that Senator Tuberville and his lawyers want. And that's why we're seeing these kind of hyper-technical, procedural, jurisdictional roadblocks being thrown up by him, because they don't want it to get to a point where they actually have to put evidence on the table.
This isn't the first time that Tuberville's residency has been challenged. There was I learned after we last talked, the Covington County suit that was dismissed, but I think it was dismissed because of jurisdiction. Are you familiar with that suit?
I am. I know about that case.
Yeah.
And yeah,
go ahead.
And that was the right ruling in that case. As I said, the courts in Alabama and elsewhere have said that political parties get to decide how they nominate somebody, and frankly, who they nominate. And so at that point, he filed that lawsuit. The lawsuit was actually filed before the primary. It was filed by one of his primary opponents, a guy named Ken McFeeters. And the court correctly found that up until the point in time that the party actually decides who their nominee is, it's not a matter for the courts to get involved in. So that was a correct ruling for that case to be dismissed. You know, it had all kinds of other problems. Mr. McFeeters had not hired a lawyer, and the complaint was kind of strangely worded. But I frankly anticipated that case being dismissed, and that's why we had to wait until the Republican Party finished its internal challenge procedure, or election contest procedure internally, because until they complete that, Mr. Tuberville was not the Republican nominee. He only became the Republican nominee when they finished their kind of pretend process that they went through, and they certified him to the Secretary of State as their nominee. At that point, we believe jurisdiction in the courts attached, and that's why we think this case will survive the motion to dismiss.
Well, you're challenging a constitutional question, so it just seems obvious to me that that's where the judiciary gets to do its job. That doesn't seem like it takes a Rhodes Scholar to figure that out. The intra-party hearing was, I think, June 14th. Closed door session, no evidence presented. Nobody knows what went on in there. On the other hand, you filed a complaint that uses the phrase manufactured residency. what does it mean in this context? And specifically, I know a lot of it is laid out in the complaint itself, but just for purposes of this podcast, what would you laundry list as things to back that up?
Well, I would say this. I mean, keep in mind that Tuberville thought about running for governor and, in fact, created a campaign committee to run for governor 6 years ago, or 4 years ago at least. No, 6 years ago. I'm wrong. Sorry. And before that, he had thought about running for governor before that. So the question of whether he lived here has come up several times every time he's thought about running. I think he settled on running for the Senate because it doesn't have a residency requirement. You only have to be a resident of Alabama on the day you get elected, and had previously thought about running for governor, but knew he was going to run into issues. Now, I think he consulted the best lawyers that money could buy, and they said, well, here are some of the things you could do now to make it look like you lived in Alabama. And one of those was to get a driver's license in Alabama. And
Good start.
Yeah, and register to vote in Alabama. Well, that
another good start.
Exactly. But as I said, those are things that can be done, frankly, with very little effort and with ever having moved, one stick of furniture from his mansion in Florida to this little house behind the strip mall in Auburn. And so what we contend is that those things, although sometimes the courts look to them as indications of residency and domicile, then in this case, they were pretty obviously done for the crass purpose of making it look like he was a resident without him actually having to live here. And so those are some of the things we refer to. I will say he didn't really put a tremendous amount of effort into it. He easily could have purchased a house in Auburn that looked like it belonged to the millionaire that he is.
Gotcha.
And he couldn't even be bothered to do that. I mean, you'll relate to this. Many years ago, I had a federal judge look at my opponent, not my lawyer, but the opposing party in a case, and say, son, if you're going to dedicate your life to being a complete fraud, at least put some effort into it.
The house, in all candor, and I know you were a Tuscaloosa person, I went to Auburn, and it resembles a place I lived in as a senior in 1974.
Okay.
I think it's in the same neighborhood near the Kroger.
Well, and that neighborhood, I know people obviously who went to Auburn and who are familiar with the town, and that whole neighborhood is, it's middle class, but it's really primarily made up of people where students live who are going to school there, or people who maintain a game day house for purposes of having a place to go visit when they go to football games. It's not where a guy that has made millions and millions of dollars being paid not to coach football and then made millions more off insider trading. That's not where he and his wife are going to choose to live. So, you start out with just kind of common sense. It doesn't pass the smell test that's really his permanent residence. And then we think, as we talked about the first time, that there's a significant paper trail that clearly indicates that when Tommy Tuberville goes home, it's in Santa Rosa Beach. It's not in Auburn.
So with that in mind, we call what happens next if the judge denies the motion to dismiss. That puts the ball in your corner to go through what lawyers call discovery, where you get to ask questions and take depositions. I know you've already deposed or requested depositions of both Tommy and Mrs. Tuberville. I trust you will be taking a look, if you haven't already, at some other things that evidence residency, such as utility bills, tax returns, insurance records. What do you expect those types of things to show? Your best judgment. You don't have to give your case away.
Well,
Well,
and
maybe you want to. I don't know.
let me say a
You've
couple.
asked for a jury trial.
I have asked for a jury trial, and frankly, I will say we did that mostly to protect. As you know, you got to request a jury trial, or you might waive it.
Right.
You can always decide later not to have a jury trial. I would be perfectly comfortable with Judge Reed deciding the facts in this case. But we at this point are scheduled to try the case in front of a jury. But there's actually one big step before we get there, and then I'm going to answer your question. But they're almost guaranteed, no, definitely guaranteed that they would appeal from a ruling denying their motion to dismiss.
Absolutely.
Yeah, there's no secret about the fact that their strategy is to get in front of the all Republican Alabama Supreme Court and hope they get some home cooking there. So that's actually the next step. If Judge Reed denies the motion to dismiss, they would promptly appeal to the Alabama Supreme Court. And then we're going to find out whether or not we really are going to be given a fair chance in this case. And I'm optimistic that there is an avenue for us to get a fair and level playing field in front of the Supreme Court. But let's assume that we get past that and we are at a point where we get to take discovery. There's a couple of competing factors. One is we're still on a very short time frame. As you know, cases and civil cases in particular can take years to ever get from beginning to trial. And we don't have that here. We've only got a couple of months. We've got to have it resolved before voters go to the polls in November. That requires that the case be expedited. Fortunately, Judge Reed has done an excellent job of grabbing this case and running with it. And, she gave us a hearing on very short notice. And I don't mean that I asked for it, so I can't complain about it. But she recognizes that this has to be resolved quickly. And it makes sense, Tommy. Voters deserve to know whether or not the guy that they might be voting for is or is not constitutionally eligible for the job. And voters need to know that before the election, not afterwards. So we will be on a quick time frame. What that means is I may not have the luxury of doing all the discovery that I would want to do if we weren't on a short time frame. But we think a couple of things. First, we have a tremendous advantage in the fact that the news media, some very good investigative journalists, have already done a lot of the footwork that needed to be done to establish some of those things. They've made requests, they've gotten documents, they've analyzed those documents, and those journalists, frankly, have done a great favor not only to us but to, I think, the citizens of Alabama by really examining this issue. So a lot of the groundwork's been done. We would still obviously want to move forward immediately with the deposition of both Senator Tuberville and his wife, because he certainly claims they both live in that little one-bedroom house in Auburn. And we think that, first of all, I think his lawyers will do everything in their power to make sure that I never get to sit in a room with Tommy Tuberville under oath asking him the kind of questions I want to ask. But I do think that those depositions will be very enlightening. In addition to the kind of things you're talking about, utility bills, what has he told his insurance company is his primary residence? What vehicles does he own and where does he keep them? So those kind of questions we've actually already asked. We just are waiting to get through these legal hurdles before Mr. Tuberville will have to answer those questions.
Under oath.
Under oath, yeah. I mean,
Subject to penalty for perjury.
Yeah, that makes a big difference. You put a politician under oath, and I bet a lot of what they say changes. I'm
a big fan of Face the Nation and Meet the Press. It's comical to me that when a question is asked, how far the politician will go and never answer the question. You almost forget the question by the time they get through saying what they have to say. A good lawyer,
Sure.
like yourself, will remember what the question was, and when they're finished rambling, go back to the question and
Exactly.
say, but where is the power bill? I get what you're saying there, but you have to be a good
Yes.
listener to ask a good question, because a lot of times you don't get the answer to the question you originally asked. I know you had a two and a.
Well,
Go ahead. I'm sorry.
I've deposed my share of politicians. I had the great joy of deposing the politician named Roy Moore.
I remember him.
And he, I wish we didn't, but I took his deposition, and he walked out in the middle of it, which was. But I had to get a court order to get him to come back, which he did. But as I said, I have a lot of experience. Been doing this for not as long as you have, but pretty close. And
that's pretty funny.
I tend to get the answers I'm looking for. At least I get the answers. I'll say that.
So yesterday, we're taping the day after the hearing that took place in Montgomery yesterday, and we will be airing this tomorrow. So it should be relatively fresh. But in that 2.5 hour hearing, what essentially did you argue?
Well, part of it was being responsive to Tuberville's lawyers, and he has hired, the best and maybe most expensive lawyers in the state to represent him. But they are my friends. Joe Espy I've known for a long time and had cases with him and have tremendous respect for him. And he made a very compelling presentation of the fact that this particular legal issue has not really been resolved by the Alabama Supreme Court. Now, I've told the judge that the reason this hasn't come up before is we've never had somebody with the chutzpah to live out of state and try to run for governor. And so it's not surprising to me that this precise issue hasn't come up before. But they point to the fact that there are some unresolved questions. Election law in Alabama in particular can be a little murky. I've been practicing it for decades and still run into questions that don't have clear answers. But we think in this instance it is clear. And our argument was, that courts exist for the reason of interpreting and applying the Constitution. And in this instance, we're not talking about just a statute. We're talking about a provision in our founding document, a provision, by the way, that's been in every constitution that Alabama has ever had since 1813, requiring that candidates for governor meet three qualifications. There's an age requirement. You got to be 30 years old. I don't think we'd be having this argument if the Republicans had nominated somebody who was 20 years old. You also have to be a United States citizen. I know we wouldn't be having this argument if the Democrats had nominated somebody who was not a United States citizen. Do you really believe the Republicans would be arguing that is solely a question for the Democratic Party to decide? But in this instance, we said, Judge, this is a pure question of constitutional law. That's what courts exist to deal with. And the notion that can be resolved just by a political party holding a closed door hearing where they clearly violated their own rules runs counter to at least 200 years of constitutional law.
I want to shift gears just for a minute, because in our legal speak, we tend to get lost about the client. You have two clients,
Sure,
both honorably discharged veterans that are bringing this case. Tuberville spent years on the Senate Armed Services Committee and took great pride in the fact that he blocked hundreds by himself of military promotions in a Senate standoff, and now he's running for governor of the state in a state that he may not actually live in. What do Brooke and Justin say about the irony of that?
Well, it's not lost on them. Let me say that. And one of the things when we started looking at this particular lawsuit, we got contacted by, frankly, dozens of people who wanted to get involved and wanted to participate and wanted to be plaintiffs. And we ended up selecting these two veterans. And, it's not a coincidence that we picked veterans. Tuberville has been an enemy of veterans since he got in power, not only blocking some 450 promotions of otherwise qualified officers, but he also voted against legislation that would have compensated veterans who were exposed to burn pits in Iraq. And in addition to that, he lied when he ran for office and said he was going to contribute his salary, every penny that he made as the United States Senator, he was going to give to veterans organizations. And he lied about that. He hadn't given them a cent of that money, kept it all, tried to get credit for being a friend of veterans when really he's an enemy of veterans. So we decided that it made sense for our two plaintiffs to be people who had served in the military and who had suffered some of the wrath of having somebody who's not a friend of veterans. And it's also, veterans, even more so than just your run-of-the-mill civilians, take seriously when they take an oath to support and defend the Constitution. They're willing to lay down their lives for it. And this is a guy who, as I have said before, Tuberville, in order to be sworn in as governor, is going to have to put his hand on a Bible and raise his other hand and promise to support and uphold the Alabama Constitution. And the very first thing he's going to do is violate it by taking office when he's not constitutionally eligible. And that kind of hypocrisy doesn't sit well with folks who have served in the military or, frankly, anybody else.
Well, beyond your two clients, there are much broader stakes for Alabama voters. If Tuberville is allowed to run without meeting constitutional requirements that we've been talking about, of course, that sets a horrible precedent. But he had 400,000 Americans voted for him in the Republican primary. What do you say to voters who feel like the courts are trying to get in their business, so to speak, interfere with their choices?
And I made this argument to the judge. Enforcing the Constitution is not a popularity contest. We don't say we're thinking about giving due process to this criminal defendant, but let's first vote on it. Let's let people decide whether they like this guy enough to have the Constitution apply. The whole point of the Constitution being the fundamental law of the land is that if the citizens don't want to follow it, they got to amend it. They don't get to just ignore it. And so the notion that 400, and keep in mind, that's 400,000 Republicans. These weren't all the voters in the state. They zealously protect the primary to make sure it's only Republicans, or at least mostly Republicans, that are voting in that. And again, nothing wrong with Republicans. Some of my best friends are Republicans, but that is not everybody in the state voting on it. I also say this, and I think it's worth mentioning, our Alabama Constitution just got ratified and readopted through a compilation in 2002. The voters voted on that. The voters adopted that Constitution, including the provision that Tuberville is violating in Section 117. So if it's really a popularity contest, Tuberville got roughly $400,000 or 400,000 votes. The Constitution got 700 and 800,000 votes just a few years ago. So if we really want to line up voters, I think those people who adopted the Constitution would want to know, why is the Republican Party think they're above the Constitution? Why does Tommy Tuberville believe that the fundamental law of the land doesn't apply to him? And those are the questions we think should be answered by the court.
We have a timeline. We briefly touched upon it. It's a short fuse by our standards because we always move in 30 and 60 and 90-day increments in the legal system. If you make a court appearance on today, sometimes it's another 2 months before your next court appearance. We don't have the luxury of that because we have a November election looming out there. So with that in mind, what do the next 60 to 90 days look like? I think I know the answer from your perspective. You'll be busy making discovery. And I think I know the answer from Joe's position, and that is he'll be going to the Supreme Court. But give us your version of what the future holds in that short time span. And mention, if you will, what you anticipate the Alabama Supreme Court doing with respect to recusal and bringing in retired judges to hear the case that are fair and impartial and not maybe a balance of Democrats and Republicans as opposed to the current makeup of the Supreme Court.
Sure. I think since we're talking about a former failed football coach, I can use football analogy, but we're going to be in the
paragraph 21 of your complaint. Paragraph 21 of your complaint.
True that. But we're going to be in the 2-minute offense, right? We're going to be pushing the ball down the field as quickly as we possibly can, conserving as much clock as we possibly can. And Tuberville is going to be trying to run out the clock and hope that he can muck it up and delay it enough. So I think we'll end up with more than one trip to the Supreme Court. It's a daunting task to get a case in and out of the Alabama Supreme Court in a short period of time, although they can certainly act quickly and have done so in cases that required it. But it's, I will say this. I think the Alabama Supreme Court is likely to recuse themselves in this matter. It is not unusual. I just looked at the case history this morning, and there are a dozen cases at least that I can find where the Supreme Court has said, look, this is we're either too close to this issue or it's too politically charged and tied to things that would require our recusal, that we need to have a special court appointed. And that is, as I said, not unusual. It happened a number of times with Roy Moore with his various litigation over being removed as Chief Justice and some of the other things. So it is not unprecedented by any stretch. And I think this is a case that would be appropriate for the Alabama Supreme Court to recuse themselves and have the Chief Justice appoint a special court. And that special court historically would be made up of retired Supreme Court justices, other appellate judges, and maybe even some retired judges. The advantage there, of course, is you've got folks who don't have to face the voters again. They don't have to worry about getting primaried in a Republican primary by somebody who feels like their decision was not to their political liking. And frankly, that would be the most elegant and ideal solution to having a court hear this issue and divorced as much as possible from partisan politics.
So let's be optimistic, and having exhausted all of those legal hoops, what does winning look like for your clients? If you prevail, what is the actual remedy? Does Tuberville come off the ballot?
Yes. The Alabama law is clear that if you are found to not be eligible for the office you're running for, you can't appear on the ballot. I mean, there is a very specific Alabama statute that says only those properly qualified and eligible can appear on the ballot. So we believe that in this case that Judge Reed could find, either by a jury or by a bench trial, that Mr. Tuberville was constitutionally ineligible, and at that point, that would make him ineligible to appear on the ballot in November. Now, there's one little catch, and that is the ballots get printed in August or September. So there is a deadline that matters, and that's, I think, August 20th. If he is disqualified and removed from the ballot before August 20th, the Republican Party has the option of replacing him on the ballot with another candidate. This happened several years ago, you may remember, with Bob Vance, where the Democrats replaced their nominee for Chief Justice, who was running against Roy Moore, replaced that candidate with Judge Bob Vance, and he became the official nominee. That can be done without a primary. It can be done by the executive committee of the party. To me, that's the ideal solution, would be to have the Republicans recognize that they've made a mistake, that they nominated somebody who's not qualified, and to allow them to replace Senator Tuberville on the ballot. Now, I don't think they're ever going to do that, and I don't think the Republicans will step up before that deadline. So after that time period, after August 20th, Senator Tuberville's name may still appear on the ballot, but any votes cast for him would be void. And we've had that circumstance as well, where somebody appeared on the ballot, but none of the votes that were cast for that candidate could be counted. That, to me, that's not the ideal solution. But our goal, and my client's goal in particular, is to have the Constitution enforced. And we believe in that case that means that Tommy Tuberville can't be a candidate, a legitimate candidate, a qualified candidate, an eligible candidate for governor, and that his name should either be removed from the ballot or any votes cast for him should not be counted.
Well, I know you have an important appointment coming up, and I do not want you to be late for it, but I'm going to ask you one more question. You don't have to talk about your appointment. If Judge Reed grants the motion to dismiss, we already have talked about the fact that it's not over, because we've got to go through the legal mumbo jumbo of getting to the Supreme Court and then whatever they do, which we just talked about.
Right.
If it ends up that Tuberville is off the ballot after all is said and done, and I know what an obvious answer would be, but let's get beyond the obvious. Who does that help politically besides Doug Jones? Is there a downstream impact in some way?
There might be. I mean, I am not so naive to think that this wouldn't have an effect throughout the ballot, all the down ballot races as well. To me, and I'd say this without a hint of a hypocrisy, I don't think, is the political impact of this is kind of secondary to me and to my clients. It is, as I said, ideally, the Republicans would have put somebody up who was actually eligible. And then we'd be talking more about the issues and those kind of things. But we end up with a candidate who's constitutionally forbidden from holding the office. He needs to be disqualified no matter who that helps politically. And I say that as sincerely as I can. To me, the goal here is making sure that the candidates who are running for elected office are, first of all, scrutinized, and secondly, qualified. And that makes all the difference in the world. And we think that ultimately is the right conclusion here. So I think that he should be disqualified. Any votes cast for him should not be counted, and then let the chips fall where they may. I mean, there is still a possibility, obviously, even if he was either not on the ballot or disqualified, that somebody could start a write-in campaign or any number of other things. But if this causes chaos or a mess, the Republicans only have themselves to blame for this. They decided to push the limits and to act with such arrogance and to take the position that they're beyond and above the law, and there need to be consequences to taking those kind of positions.
Thank you, Barry Ragsdale, Birmingham attorney, constitutional litigator, lawyer standing in the gap for two Alabama veterans who believe the rule of law means something, which I do. And as a matter of fact, did a whole season about the rule of law. Here's what you need to know going forward. Judge Reed's going to rule on that motion to dismiss, and whatever she decides, the Alabama Supreme Court is probably the next stop. The case is far from over. The stakes could not be higher. And I guess the real question is, does the Alabama Constitution mean what it says, or does it mean whatever the party in power needs it to mean? So thank you for being with me. You have heard what I believe to be the real truth. Thank you so much, Barry, for your time.
Thank you, Tommy. Enjoy your 4th.
Same to you. Thank you for joining me today on The Real Truth. My name is Tommy Spina. I hope you enjoyed today's conversation. I hope you will follow or subscribe to my podcast and listen in to the next episode. If you found it valuable, please take a moment to rate it and review it. It helps us to reach more listeners that care about the issues that matter. Share it with a friend. Stay engaged and remember, the truth matters. I'll see you next time.